Welcome, viewers, to our 25th annual Autumn Estate Planning Seminar. We're members of Chipman, Mizuko, Emerson, a Danbury and Southbury, Connecticut law firm. My name is Richard Land. That's me in the box at the bottom right corner of your screen. Next to me, you can see three other Chipman Mizuko members preparing for our presentation. They are Jim Flaherty, Allison Marcusio, and Dick Emerson. In the past, our annual seminars looked like this. You'd see a lot of people having a good time at the Ethan Allen Inn, where we usually hold these meetings. Times have changed, however. We didn't want to let the COVID scare break our long string of these gatherings, so we decided to try this out, a recorded seminar. There are no face coverings and no fear, but, on the other hand, there's a lot that we miss. Food, drinks, cordial smiles and handshakes, and the chance to reconnect with old friends. There is something, however, we don't need to miss, an opportunity to stay current on matters that relate to your estate planning. So that's why we're here. Our presentation will be in 4 parts. They'll be described later, so I won't go into the details now. Instead, I'll bring this introduction to an end. I hope you enjoy the seminar and find the information helpful. Here it is.
Hello, viewers. We are gathered here today for our 25th annual estate planning seminar. It's a little bit different than normal because in this era of COVID, we're doing it remotely, whereas we've always done it in the past at Ethan Allen. We have four different speakers. I'm one of them, and they're going to be talking about a variety of estate planning topics. And the first one is going to be Jim Flaherty. He's going to talk about estate planning in uncertain times. And then I'm going to talk about a new act that covers retirement account planning, and that's called the Secure Act. The third speaker is going to be Allison Marcusio, and she's going to be talking about the 5 most frequently asked questions relating to elder law. And then the fourth speaker will be Dick Emerson, who's going to give you some guidance on how to make the probate process go easier after you've passed away and you're trying to hand the assets down to your beneficiaries. So I'm not going to delay any further by talking anymore. Here is my partner and longtime estate planner, Jim Flaherty.
Well, thanks, Rich. As I kind of looked at this in planning for our seminar, normally we do have a nice crowd and we're doing it live, and so it's quite a bit different. For this one, though, this year, given everything that's happening, we're just fortunate to be able to talk to you. I'm going to talk about estate planning in uncertain times, and believe it or not, it's going to have nothing to do with COVID for a change. We're going to be talking about the upcoming election, the tax laws as they are today, which drive a great deal of our estate planning. So to give you just a little bit of a refresher as to where we are today, when we do an estate plan, it's driven by 2 things. One, it's where's your property going and how is it protected for you and for your heirs and beneficiaries. And the second thing we want to make sure of is that there are no adverse tax consequences to anything we might do. So estate taxes being first and foremost on the list, we're very fortunate these days in that the 2017 tax bill enacted in Congress raised the exemption amount to better than $11 million. And today it's $11.58 million that could pass to your heirs free of estate tax. Just 4 short years ago, it was $5.49 million. And for those of us who've been practicing for a while, back in the 90s, we had an exemption amount that was as low as $600,000. So you can see the range in which we would have issues with respect to estates and estate planning, given the exemption amount. With an $11.58 million exemption, fewer and fewer people fall within the estate tax regime. However, there are 2 caveats with this current level. One is that in 2026, it goes back to the roughly $5 million exemption amount. There's a sunset provision in the current legislation, unless Congress moves to make it permanent. The second is, of course, we're coming up on an election, and who knows who's going to win. There are a lot of rumblings in Washington about if the Biden ticket wins, that we're going to see a reduction in that estate tax exemption. What it's going to be, no one really knows, and a lot will depend upon the makeup of Congress as well. So we're unsure at this point whether 11.5 million is going to be the number, or somewhat closer to 5 million, or I've seen the number 3.5 million thrown about quite a bit lately. So who's to know? The second thing we have to consider with estate tax is the state estate tax. Connecticut has its own estate tax. And a couple of years ago, surprisingly enough, they enacted legislation which said the exemption in Connecticut is going to be raised to mirror the federal exemption. And it's done over time. So by 2023, whatever the federal exemption is, that's what the state exemption is going to be. Currently, it's at $5.1 million. As of January 1 of 2021, it's going to raise to 7.1 million, up to 9.1 the year after that, and then 2023 hits and mirror the feds. But what happens if we see the reduction in the federal exemption amount? Connecticut, by statute, will follow suit. So it makes it very difficult for folks who are in that $3 to $10 million range as to what sorts of things we should be doing, how we should be planning going forward. Another issue with respect to estate tax and estate planning is the portability feature of the current federal exemption amount. For a husband and wife, for spouses, that portability feature follows so that at the first death, if we don't use the exemption amount there, the second spouse will assume that amount. So it's roughly $23 million that could pass to heirs free of estate tax, given portability, at the second death. Because remember, everything that passes to a surviving spouse goes free of estate tax. Connecticut does not have that same luxury. That we have to plan to be able to use the exemption on the Connecticut side at the first death, rather than hold it over to the second. So, like I said, we don't know what's going to happen. On top of everything else, given the stimulus packages that have been enacted, given the budget constraints that Congress is facing and our state will face as well, we may see, independent of all of the political issues that we're facing right now, we may see a rollback of that estate tax exemption anyway, simply as a revenue generator. So what are we going to do about all of this? For us, and for me in particular, when I'm drafting for folks who are in the $5 to $10 million range, as far as their net worth is concerned, I'm looking at drafting as flexibly as I can. For those of you who did estate plans back in the 90s, back when the exemption amount was $600,000, you always had separate trusts for each of the spouses, and they had what we call a formula clause in there, carving out the exemption amount of $600,000 and saving that, the use of that exemption at the first death. We're staying, at least I'm staying away from that for the most part. And I'm using a thing called a disclaimer. So we'll do a lot of planning after the death of the first spouse. We simply create a trust that's flexible enough to handle that. So if at the death of the first spouse, we say to ourselves, okay, we don't have an estate tax issue perhaps today, but we know we're going to have an estate tax issue at the second death. We'll carve out portions then, place those in trust, which would not be includable in the second spouse's estate, and use it that way. Another very effective tool is a power of appointment. I'm incorporating that more and more in my documents these days because it allows the next generation to make some choices. For example, you have property passing to a surviving spouse and then at the spouse's death on to children. That surviving spouse could appoint property, meaning he or she could direct under the terms of his or her will, ultimate beneficiaries, which would ordinarily have been the children, could be someone else. It could be grandchildren. We could skip a generation, if you will, and move those assets down beyond the next generation if that next generation could have an estate tax issue. Kind of bypasses them. It also, from an estate planning standpoint, helps in the event that perhaps a child is undergoing special challenges in life, say creditor issues or a divorce or bankruptcy, and the surviving spouse may say, you know, it's not the right time for you to be getting anything outright. Let's create a special trust for you so that the money is protected until you have overcome these challenges. So those are two of the biggest drafting techniques right now that we're using in order to stay as flexible as we can. Another option, and we'll know more because the sunset provision gets us out to 2026. It sunsets in 2025, the federal exemption, without action by Congress, as I said, and it will drop back down to $5 million. We may want to make particularly large gifts to the next generation, and we would do that now or in the coming year or two. Depends, of course, on, again, the election and what we think might happen, but making those large gifts now. So for an estate, a couple who has, say, $25 million, we may want to move a little better than $11 million now, perhaps into trust for the next generation, but for whatever reason, move it out now. The IRS has given assurance, because they were provided with this authority under the tax legislation in 2017, to make these sort of technical pronouncements, and they have said that they are not going to claw back gifts. So if the exemption amount is 11.5 now and it goes down to 5 million, they're not going to claw back that extra 6.5 million in gifts and assess tax against those. That's at least what they're saying today. And there's no reason to believe that they would not follow through with that. So when we're gifting, the next issue that we're going to look at is not estate tax necessarily, but capital gains tax. All too often we have clients come into the office and say, you know, I really want to make sure the family home stays in the family and I want it gifted. I want to do a quitclaim deed to my kids. We're going to stay in the house, but I want the house to be titled in their name. And we'll have a long talk about whether or not that actually makes sense, given the fact that they're placing the house under the control of their kids, who theoretically could say, Mom and Dad love you, but you got to get out. Or Mom and Dad, I've got a bankruptcy creditor. I'm going through bankruptcy and your house is part of the mix. Or Mom or Dad, I'm getting a divorce and it's part of the settlement. As part of that settlement, the house is part of the mix as well. So that loss of control can be very disconcerting, if you will, for people, and they'll think twice about it. The bigger issue that people don't often think about, however, is what happens as far as a capital gain is concerned. Now, there's an exclusion for capital gains for your personal residence for a married couple up to $500,000. As far as property which is not your principal residence, there is no exclusion for part of the capital gain. Uh, so what happens ultimately when the kids do sell? If we give the house to the kids and at the death of the second of the spouses, the kids say, none of us want the house, it's time to sell it, and it's been in the family for years, there's probably a very low basis in that property. The gain or the amount above that basis is taxed. That's not true necessarily if the house passes to the children under your will or trust, if you maintain control over it. And the capital gain can be extraordinary. I mean, we're looking at 20% of the gain. So for someone who bought a house in the 60s for $10,000, and that house is now worth $500,000, the math isn't too difficult to do. So those taxes are avoided by not making a gift to the house necessarily. Last of the list is think about charitable gifting. You know, back when we had a discrepancy between the federal exemption amount and the state exemption amount, and we were talking about portability, and we were doing some formula work which said in order to, because the state of Connecticut had what we call a cliff, and when you reached a certain level, if you went $1 more, you were taxed on everything. If you went $1 less, you were exempt. So there were formulas in our documents which said charitable gifting is permitted up to the amount where it eliminates the Connecticut estate tax. The same could hold true, although we don't have the same worries about gifting or about estate tax and gifting. But the same could hold true if you were charitably inclined and there was a possibility that we could see large reductions in what would be exempt from estate tax. So maybe incorporating charitable giving into your estate plan is probably a good idea if you're so inclined, because there's a dollar for dollar deduction on those charitable gifts. Just as kind of a recap, what we're really trying to do is stay as flexible as we possibly can. If we go back to the days, such as in the 90s, when we had all of those formula clauses, it will be because the exemption amount has become so low that it hits more people than not. But we want to be able to take advantage of the things we can and not get caught up in an estate tax regime that could be confiscatory at best. I mean, you see rates which right now the top marginal rate for estate tax is 40%. We're seeing proposals that get it upwards of 60%. I even saw one that was 75% of the amount over the exemption amount. So do I think they'll end up there? No. But it wasn't too long ago that the top marginal rate was 55%. So those days can come back. But it'll be important to watch and listen to your advisors and revisit your estate plan, not just for estate tax purposes, but things can change. Family circumstances can change. Value in wealth can change, all of which affects your estate plan. So be sure to watch it, review it periodically, and we can make adjustments fairly simply in most cases, which will get you where you need to be. So I'm going to turn the floor over now to Rich Land, who's going to talk to us about the Secure Act. Rich?
Thanks a lot, Jim. I am wondering if anybody has any questions for you first, that maybe you think some clarification is necessary, and a few questions will contribute to that. I know while you were talking, I was thinking there are quite a few nuances to what you had to say, especially when you're talking about the disclaimer trust. I know Allison probably will want to bring up that the disclaimer trust doesn't have any creditor protection features to it. And when you were talking about the power of appointment, which can be so important in estate planning, the disclaimer trust can't include powers of appointment in the surviving spouse. So there's a lot to talk about when you're talking to a client, and it really does take time and attention to understand what the client wants and needs, and somebody like you who knows all the ins and outs is a necessary part of the process. So I wanted to clarify those two things instead of viewers, possibly they'd come away with it with an idea that a disclaimer trust can do more than it does. And also I thought maybe an opportunity to give other people a chance to ask questions. Anybody else? No?
I was just wanted to mention with respect to the capital gains tax implications in my part of the discussion later on the frequently asked questions, elder law questions. One of the questions has to do with transfer of primary residence to your children. And while I'm not going to get into great detail about what those implications mean, I was going to touch on, the capital gains tax implications of making that transfer, but also how that might be a little bit different if the parents were to retain life use of the property.
One other thing I wanted to mention while, or that came to mind, you talked about the cliff tax in Connecticut and how we don't have that anymore. Well, they have it in spades in New York. So for those New York viewers, they might want to keep in mind that once your taxable estate gets above the New York exemption by, I think it's 110, 105% above, something like that, there's a cliff tax that's imposed that's very burdensome. And it really would make a lot of sense to arrange your plan so that the portion of your estate that gets above the exemption could be disclaimed to a charity. I mean, that's very important. So
Isn't that the case in Massachusetts too? Is there a cliff in Massachusetts?
not sure, but Massachusetts folks, if you're watching, watch out.
Jim, do you know?
I don't know offhand. I
Okay.
do know they've got their estate tax, and
Isn't their exemption only $1 million?
that's correct.
Yes.
Okay, I hope I didn't take up too much time with questions, but when I talk, which is now, I'm about to start talking. Actually, I've been talking for a while. When I start talking on my topic, I want to invite questions because I'm sure I'm going to breeze by some things. It'll be unclear. The best way to clarify is to enter into a conversation sometimes. That's why it's important to have a client sitting in front of us, back and forth, actually coming to a meeting of the minds about what clients want.